and it can still be...
Sorry to interrupt the honourable member. Her time has expired. Call David Clendon.
Thank you, Mr Speaker. I'm pleased to speak to this bill for the first time to state the Greens' continuing support for the bill, despite the fact that, somewhat like the Labor government, we don't see any particular need for it in the form that it has been presented. My esteemed colleague, Keith Locke, spoke to the earlier readings of this bill. With his departure to greener pastures, I've inherited the task. It took, of course, remarkably little time to read the bill in its entirety, a very few number of paragraphs, one substantive clause. It is undoubtedly the shortest piece of legislation in my experience, admittedly limited experience. There seems to be no particular justification for this bill. Our reasons essentially for supporting rather than opposing is that to oppose could be seen to oppose what is basically judicial practice of the time. The judiciary does acknowledge that assault on police or prison officers is a serious matter and is treated as if it is an aggravating issue. And for that reason, I guess we are continuing to support this. The Crown Law Office, in their review of the bill, were quite unequivocal, and I quote, "New Zealand sentencing decisions take into account the fact that the victim of an offence was a police officer or a prison officer acting in the course of his or her duties. As a matter of established practice, the bill confirms the common law position," end of quote. So clearly this bill is almost superfluous, though clearly there is opportunity within it to make it do something useful, to make it do something better. Mr Cheval has already listed some of the existing aggravating factors mentioned specifically in the bill. These include the actual or threat or use of violence, the threat or use of a weapon, and clearly these are appropriate to be referenced in a bill, in the sentencing bill. People have the right to the security of their person. It's a basic tenet of our law that people ought to feel secure in themselves, to be safe from assault upon themselves. The aggravating factors include unlawful presence in a dwelling place. Again, people have a right to feel secure in their own homes, in the places where they live and work, and if that security is lost, that is a significant issue, that is an important thing, and it is a fundamental role of the state to protect the security of the person, of the home, and those. And in that sense, clearly these aggravating factors already identified are somewhat generic, less specific, and that's as appropriate as one would want it to be. The list clearly is not definitive or exhaustive, that is in the existing legislation. There has been no specific reference to date to police or corrections officers. It is acknowledged that police and prison officers do put themselves in harm's way. Judges take that into consideration, and we can demonstrate that through case law and through simple observation. And the case law, in fact, quoted by the Crown Law Office, goes back at least to 1980 and up to the early or mid-2000s. It is current practice, it's been practiced for quite some time, and it's questionable that we really need to take this step. The judiciary do their best to protect police officers. They are not loath to impose quite significant sentences on people proven guilty of assaults on police or prison officers. But we must also bear in mind that length and severity of sentence are not in any degree proven to be deterrents for potential offenders. The Police Association themselves support this view in their submission. They state there that they concede that simply adding longer or tougher sentences is not a deterrent, particularly to violent crimes, which, as has been pointed out, are typically irrational, spontaneous actions. People plan burglaries, they plan to deal in drugs or other illegal activity. Violence, particularly against police and corrections, is often a reactive, spontaneous action. You can have the longest toughened sentences in the world. It'll make not a blind bit of difference in that moment when somebody offends against an officer. So let's not delude ourselves or be under any illusion that these sorts of measures that this bill would put in place will actually make our community safer, our police or prison officers safer. And I would add to that, in my belief, I say now, and we have said consistently over the last several years, that a lot of the actions of this government, the former government, actually have made our prisons and our streets more dangerous. And I think of things like 3 strikes, like double bunking, like the imposition of tougher penalties and more severe terms for inmates in our prisons. Those have all contributed to making the job of our corrections officers more dangerous. Words on paper will not remedy that. In that sense, this will not be particularly effective. The Select Committee, and it must be conceded, I did not sit on that committee, and I'm sure the House will be thrilled, as we are, that the Greens are now in sufficient number that we will have sitting members on every Select Committee and will be able to participate. We're very happy about that. Indeed, I'm sure you are. Thank you. The Select Committee did deal with these 2 issues. I made comment of the notion of reciprocal aggravating factors and the situation affecting other public servants or other people in the public sector. The notion of reciprocity is suggesting that given that police are in a unique position, we could say, that if they are to be uniquely protected, then they also should bear unique responsibility, shall we say. And it was captured quite well by the Council for Civil Liberties in their submission, where they said, and I quote, that if offences against police and prison officers are to be elevated to the status of aggravating factors, then it is logical that offences by those officers are elevated to the same status. And there is perhaps an implied suggestion in the existing aggravating factors that a person in a position of authority ought to be treated more severely by the courts, a person in a position of trust. And clearly that does encompass police and prison officers. But we do think that there is an argument to be made that there ought to be that reciprocity, given that the specific rights of police and corrections are to be embedded in law, then it seems reasonable that the unique responsibilities of those roles also should be acknowledged in this law. And that is something we'll be bringing to the committee stage of this conversation. The notion, the matter of other public sector officers of various forms, the vulnerability of some of those people who are providing very significant public service also, we think, could usefully be acknowledged in this legislation. We could start with nurses, ambulance drivers, doctors, people working in emergency departments at hospitals. We could think of people working with mental health, in mental health services. Things as basic as noise control, animal control officers. But I would make a special case for an example like fisheries officers. The penalties for people offending against fisheries legislation are very, very severe, can involve significant loss of property, of vehicles, of boats, of dive gear, loss of liberty at the extreme. Fisheries officers are often working in very isolated situations against people who have considerable motivation, dare I say, to respond potentially violently against being restrained or arrested by a fisheries officer, taken to task by them. So I would suggest that there are cases where this sort of aggravating factors ought to specifically cover some of these other public servants, often doing a very difficult job in very vulnerable situations where they are vulnerable to violence against themselves, and even in small communities, violence or threats of violence that could affect their family, their social life. I do think if we're going to look at amending this section in the bill, we should think a little more broadly. I think I will end my contribution there, except to say, yes, that we will continue to support this legislation. In its current form, it does no particular harm. It could be amended to do some positive good, and we do look forward to suggesting some amendments, some additions to it at the committee stages. Thank you.
Call Jonathan Young.
Mr. Speaker, I am pleased to stand in support of this bill and note that parties on the other side of the House likewise are supporting it. I do want to say that we continually hear that